Hello, viewers. As you will aware that I am Dr. Jetling Losa, running a YouTube channel called Law Speeches. In this my channel, I am regularly posting my lectures on various aspects of law, also the world affairs. So before going into my subject, I would like all of you to subscribe to my channel, watch my videos and shorts, make necessary comments, and also share among your communities. So today we discuss another international body which is called International Criminal Court, in abbreviated form it be called as a ICC. You know, the First World War, the Second World War had impacted the humanity, and the existence of human itself became a scared. There is a total devastation. In the First World War, the atomic bombs were used. In Second World War, the nuclear bombs were used. And anyhow, the war has ended in 1945, and we have seen the new horizon of the United Nations organization for avoid the scourge of war. And after that, the war devastated world has to be developed. With that regard to view, we have formed the United Nations organization on 24th of October of 1945 after much deliberations. But the UN Charter provides utmost importance to the human rights. With that view, it has enacted number of enactments of covenants like the Universal Declaration of Human Rights of 1948, then civil and political rights, socio-economic rights of 1966, child rights, human rights, CEDA. So all those things have been made under the aegis of the United Nations organization, but we have certain persons have been committing certain excesses. For that there is a no law. They did not come under the any sort of law. That is one aspect. The other aspect is that we have the doctrine of sovereign immunity. So head of states, head of governments, they are enjoying sovereign immunities under their respective constitutions. Though they are committing war crimes, they are committing genocides, they are committing aggression, but there is a no law was there till 2002 to take into consideration. The UN had made efforts. In 1998 there was a conference of 160 states were conducted, and on 17th of August of 1998 the International Court of Criminal Court has been constituted or came into force, that we called as the Rome Statute. So it was signed in the Rome, Italy, and which came into force from on the date of ratification of the 60 states. But at the time of ratification, 66 states have been signed the document, and which came into force from the 11th of April 2002. So what does it mean by International Criminal Court? Why we have constituted the International Criminal Court? I just told you that there is no responsibility is there for committing the war crimes, committing the aggression, committing the genocide, and they're taking the concept called sovereign immunities, sovereign sovereignties. So that to avoid it, we have made this wonderful charter, that is the Rome Charter of 2002, which came into force, and but we made in 1998. You know, before going into details of the International Criminal Court Charter, you know, the former Secretary General of the United Nations Organization, Mr. Kofi Annan, he remarked that this cause is the cause of humanity. For that purpose, we have made the statute of the International Criminal Court. You know, the statute provides around 13 parts, and there are 128 articles are there in the statute, which dealing with the all the major aspects, which provides what is meant by war crime, what is meant by genocide, what is meant by aggression. So all those things have been elaborately discussed and inserted in this 128 articles, and the statute also providing that there should be judges to try the offences, and there should be a conflict of laws, and for that also that has been clearly mentioned, clearly solved, and there should be an office of the chief public prosecutor. He will conduct the trials. So the administration, so everything has been clearly discussed and defined under this International Criminal Court Charter. So with regard to in details of the charter, I told you that charter is divided into 13 parts. The part 1 provides the establishment of the court. The court has been established in the Hague, where the International Court of Justice is there. So side by side, the International Criminal Court also been established in the Hague. So those was there in the Article 3 of the Constitution of this International Criminal Court. And Part 2 provides the jurisdiction, admissibility, and application of the law. So that is very important. Jurisdictional point of view is very important. So, just I told you that we are sovereign countries ruled by different sorts of governments, different sorts of forms of constitutions. So every constitution is providing some sort of immunity to the heads of states and heads of governments, whether how they can be liable for the war crimes, for genocide, for war of aggression. So all those things have been clearly mentioned from in the part 2 of the charter, that will be called as the very important part, which provides in detail regarding this thing, where Then we have the part second also provides under the Article 5, where when the International Criminal Court will come into picture. So it says, Article 5 says that crimes within the jurisdiction of the court limited to most serious crimes of international community which affects upon the international community at large, those only will come under this International Criminal Court charter, or to say jurisdiction. Then what are those international crimes? The charter clearly provides that also. That is the one is crimes of genocide. So genocide is killing of the human beings without any sort of reason, authority, or mass killing of the certain persons that is happening in around the world, like in currently in Gaza, in Sudan, in some unrest countries it is happening. Then the second is the crimes against humanity. So the states have been forbidden to commit any sort of crime against humanity, because human beings should be there. Without that, how the world can survive? So with that reason, that also been added into the under the International Criminal Court. The third is war crimes. So war crimes means crimes which happened during the time of war. So we have the principles of war is there under the international law. When there is a war between the two countries, they should have to adhere to certain practices. So the non-combatants and the civilians cannot be attacked during the time of war. And the poisonous or nuclear warheads cannot be used against in the war against the civilians. There should not be any sort of mass killings. There should not be any sort of rapes, inhuman treatment to the prisoners. That also comes as a war crime. For that also we have the international humanitarian law is there that provides how we have to rehabilitate the victims of the war. All those things are there. Then the other thing is that crime of aggression. So the states cannot do whatever it may be the power. They are holding economically, socially, militarily, or any sort of power. They should not resort to aggression, policies of aggression, or occupying the other territories, or declaring that those territories have belonged to us, and declaring without any reason, declaring war. So all are entering to the other territories without any sort of reason, that we call as a aggression. So if those comes under, if the heads of states or governments or whoever may be commits these sort of offences, they be liable for prosecution under the International Criminal Court. And so in detail, everything has been mentioned in the part 2 of the International Criminal Court statute is concerned. And the part 3rd of the statute provides general principles of criminal law. So there should be generality of the criminal principles, because there is a lexi loci is there. Criminal law is a purely lexi loci. That means that maybe one thing is offense here, but may not be offense in other territories, other countries. So we have to make adjustments. And for that is reason the part third is accommodating such matters. And part and part fifth, sixth and seventh deals with the penalties. So what kind of penalties can be imposed against the erring state parties with regard to this, that has been detailedly enumerated. And there is a part 4, part 8 also provides the appeals and revision. If there is a appeal, if they convicted, indicted in certain offences, they can be make an appeal. And the part 9 provides the international cooperation and the judicial assistance. So the persons who are accused of these sort of offences, they should be given legal assistance, and also there should be international cooperation should be there. Without that, the person cannot brought to justice. Then there is a enforcement. Part 10 provides the matters pertaining to enforcement, how to enforce the judgments passed by the International Criminal Court, that has been provided in the part 10 of this International Criminal Court statute. Then we have the part 11th, which provides the assembly of states parties. So this assembly of parties, who are the members, all are be given a single vote, and they have to given single vote, and they have to exercise their voting when there is a consensus was not there, because majority of matters should be agreed upon basing upon the consensus. If the consensus are not there only, then only voting is conducted. Then part 12 provides the finances, how the finances should come to the International Criminal Court organization, and also the part 13 provides the final clauses. So what are the matters which are left over, in which it has been provided. Then Article 5 to Article 7, which speaks about the other important matters like the judges, the election of the judges. So the member states can appoint or nominate the judges to this court if such nominated person should have the qualification of holding the highest position in that respective state. Like the International Court of Justice, the same process also been adapted in the International Criminal Court matters. And the another important aspect we have to remember is that the judges are appointed for the term of 9 years, and there are totally 18 judges are there as on today, as per the statute is concerned, and also they elected for tune of 9 years, and every 3 years there is a triennial elections will be conducted to the post of the judges. And the another important aspect we have to know regarding the International Criminal Court is that the prosecutor, office of prosecutor is a very, very important office which prosecutes the erring heads of states, governments, or persons who committed all these crimes, like I told you, the genocide, crimes against humanity, war crimes, and crimes of aggression. If they commit intentionally without any reason, they are liable for prosecution. That will be looked after by the office of prosecutor, and is assisted by the assistant public prosecutors. So, as on today, the important countries like India, China, United States of America, Russia, they have not signed this statute. Only few Western countries and some other small countries they have signed, but majority of the countries they have not signed this statute. So it speaks about the ineffectiveness of the International Criminal Court. Even recently we have seen in case of Russia versus Ukraine, the International Court of Criminal Court has passed. The Office of Prosecutor, judges, they passed, indicted the incumbent President Putin of Russia for committing this aggression. But he so far is not arrested. And it is a beyond. Why? Because Russia is not a party to the convention. And major states have not subscribed their signatories are to this criminal court statute. And though there are 124 members are there as on today, but the majority, the effective are states, big players, they have not joined this International Criminal Court till date. So it's a time there should be a consensus should be there. So it has to be expanded. United Nations organization should have to take its good offices to pursue such non-joined parties into the International Criminal Court for joining. And in addition to this, as on today, there are there are number of cases are there, like defendants at large, there are 20 cases. Defendants, there are 57 persons have been accused of defendants, and the total cases are 32 cases are pending in the International Criminal Court. And there are 12 cases have been under the investigation process. And in the International Criminal Court prosecutor has completed the 5 investigations till date, and there are preliminary examination is going on with regard to 3 cases. So, how to make it as an effective organization, an international body? For that, we have to make a concerted effort. Just I told you that major states like India, China, United States of America, Russia, they have not joined because of their various reasons. So it is a high time we have to pursue those countries, because much of the population of the world resides in these countries. And there are the Russia and America are superpowers. And economically they are not, when they are not members, they are not cooperating in economically also to this organization. So sustenance of this organization is at stake, though there are 124 members are there. So India, China, Russia and United States of America has to rethink its policy, though they have domestic compulsions are there, no doubt. But India also a country which believes upon the brotherhood among the world. So it is on part of these countries to join and strengthen the organization. And you know, though there in number of cases it has indicted, the ICC indicted in Sudan, Al-Bashir case, very back, very long ago, about 2011, it has indicted the Al-Bashir of the Sudan ruler. Though he was so far not arrested, he was not brought before to the International Criminal Court. And Uhuru Kenyatta, a former president of the Kenya, he indicted in 2011 and against crimes against humanity, but he is so far not arrested. And we have to strengthen, because it is also a United Nations sponsored treaty. So the members, the major players are not joined in this treaty, means it becomes an ineffective treaty. So the United Nations should take active action to pursuing the more joinings like the major powers. Then only we could see the avoidance of these kind of crimes to be occurrence, because these are not a small crimes, which are very big crimes which affects upon the peace around the world. The main duty of the United Nations Charter, the formation of the United Nations, is to maintain the world peace, tranquility. If this charter is not strengthened, maybe the existence of the United Nations also becomes a questionable thing. And as on today also, Russia-Ukraine war is going on, and Israeli, Gaza, Palestinian war is going on, and also Sudan, North Sudan, South Sudan war is going on. Though there may be some sort of agreement, but Somalian conflict is there, Houthis problem is there. So number of problems are there in the world. And it is a duty upon the United Nations organization to see that there should be a peace should be prevailed in the world. With that view only, the International Criminal Court is constituted. So we have to work for the strengthening of this International Criminal Court. Then only we can protect the human rights of the citizens of around the world. So then only we can attain egalitarian society in the world. Then only we can attain peace and security of the world. So thank you for patiently hearing my lecture. And I called upon all of you to subscribe to my channel by clicking the button which is there upon your screens, and watch my lectures and make necessary comments so that I can make a correction to my lectures. Thank you, one and all.